Welcome to the deep dive.
Yeah.
Today we are immersing ourselves in something absolutely fundamental, not just to family life, but, to the very structure of law that governs it. We're talking about who is legally recognized as a child's parent and what the law means by that crucial concept, parental responsibility.
Yeah, it sounds straightforward perhaps, but it's really not.
Exactly.
Okay.
It might sound simple, but as we'll explore, the legal landscape in England here is surprisingly complex, especially when modern family structures and technology come into play.
It's a vital area to understand. Far from being a simple matter of biology, the law has developed quite nuanced rules to determine legal parentage and define the responsibilities that go with it. Grasping this foundation is essential for navigating, well, pretty much any aspect of child law.
Absolutely. Now, a quick but very important note. This deep dive is made possible by materials generously provided by the University of London. We are incredibly grateful for their contribution, making these resources available for educational purposes.
Here, it's fantastic they support learning in this way.
And this deep dive is proudly brought to you by Sinorbit Academy, Sri Lanka. So to all of you using these materials to prepare for exams on this topic, we wish you the very best of luck. We hope this conversation serves as a really helpful guide as you dive into your studies.
Yeah, definitely. Our goal today is to pull out the most important nuggets of knowledge from these sources, giving you a clear understanding of the key concepts without getting lost in every single detail, while still hitting the necessary points. Think of it as clearing the path through the legal complexities.
Like a shortcut to the essentials. And much of the current legal framework we'll discuss dates back to a landmark piece of legislation, the Children Act, 1989.
The CA 1989 came into force on 14 October 1991, and it really was revolutionary. It was described at the time as the most comprehensive and far-reaching reform of child law. Well, ever, really.
Wow, that kind of description tells you this act wasn't just tweaking things, it was a complete overhaul.
Precisely. Its main objective was to create a single, consistent, and comprehensive legal code for children. It replaced loads of fragmented laws from earlier decades and, crucially, brought together both public law, like care proceedings, state intervention, and private law, like disputes between parents, aimed for clarity, coherence.
Okay, makes sense. So by the end of this deep dive, what should listeners ideally have a solid grip on? What are the key takeaways?
Right. Well, you should understand how legal parentage is established, including in those tricky scenarios involving assisted reproduction and paternity disputes. You'll know the legal definitions of mother and father under English law, which aren't always intuitive. And crucially, what parental responsibility actually is its definition, what it entails in practice, who can hold it, and importantly, how they acquire it. And finally, we'll look at how the Human Rights Act 1998 has, influenced some of these fundamental concepts.
That gives us a clear roadmap. Let's start with what sounds basic but immediately gets complex. Parentage and legal parenthood. Are they the same thing?
Not necessarily, no. And this is our first key point, really. Biological parentage, the genetic connection, and legal parenthood, the status recognized by the law often overlap, sure, but they are not always identical.
Okay, why is that distinction so important in law? What hinges on it?
Because legal parenthood is the gateway to legal rights and obligations. Most importantly, it's usually the basis for holding parental responsibility, which is that specific legal bundle of rights, duties, and powers that allows you to make decisions about a child's upbringing.
So just having a biological link doesn't automatically grant you those legal rights.
Exactly. And this is most evident in cases involving assisted reproduction, think egg or embryo donation or surrogacy. These techniques can create situations where a person is biologically linked but not a legal parent, or, vice versa.
Right.
Cases like L Teaching Hospital's VA No. 2 back in 2003, or the really complex ethical questions in the Blood case in 97 dealing with posthumous use of sperm. They highlighted early on how biology and legal status wouldn't always align anymore. The law had to catch up.
Okay, let's tackle establishing legal parenthood piece by piece then, starting with the mother. Seems like that should be the easier one.
Historically, common law was straightforward. The woman who gave birth was the mother. Period. Simple as that.
Right. Until technology changed things, I suppose.
Right. The Human Fertilization and Embryology Act 1990, and later the updated HFEA 2008, codified this for the era of assisted reproduction. For children born after 1 August 1991, under the 1990 Act, and reenacted for births after 6 April 2009, under the 2008 Act, the rule is crystal clear. You find it in sections like 27 of the 1990 Act, carried over into the 2008 Act. The woman who carries and gives birth to the child is the legal mother.
The woman who physically goes through the pregnancy and delivery. That's the defining factor.
Yes. And this is the rule regardless of whether she is genetically related to the child, meaning even if she used a donor egg. And importantly, no other woman is treated as the child's mother unless there's a subsequent legal process like adoption or a parental order.
That seems very decisive, doesn't it? Even in the face of genetic ties elsewhere.
It is the law's clear position. A really interesting, maybe unexpected application of this rule came up in R. Alfred McConnell and YY, the Registrar General for England and Wales. That was in 2020.
Oh, I remember hearing about that one.
Yeah, in this case, a transgender man had given birth. Because the HFEA definition focuses squarely on the biological act of carrying and giving birth, the court held he had to be registered as the mother on the birth certificate, despite his legal gender.
Wow, that really highlights how strictly the law adheres to that biological act of birth, even overriding gender identity or, traditional understandings of mother.
It's a powerful illustration of the statutory definition. The Supreme Court declined to hear an appeal on this, confirming the Court of Appeals' interpretation of the existing law as it stood.
Okay, so the mother is the birth mother. What about establishing legal fatherhood? You mentioned that's more complicated.
It certainly is. There are essentially four main paths to legal fatherhood in English law. First being the genetic father, though, as we'll see, the HFEA creates quite a few exceptions to that. Second, being presumed in law to be the father. Third, being treated as the father under specific HFEA 1990 or 2008 provisions, particularly in assisted reproduction scenarios. And fourth, acquiring status through an adoption order or a parental order.
Let's start with those presumptions. What are they?
The main historical one is the presumption that the husband of a married woman is the legal father of any child born during the marriage. It's a long-standing presumption.
Right.
However, with modern DNA testing, courts are much less reliant on this presumption when there's definitive evidence to the contrary. The case of Re H and A, children from 2002 actually noted this, kind of questioning its relevance in the age of easy DNA testing.
So DNA evidence generally trumps the marriage presumption if there's a conflict.
Yes, these presumptions are rebuttable, meaning they can be overturned by evidence, and DNA testing is the usual way to do that. Another presumption arises if a man's name is listed as the father on the child's birth certificate.
Oh.
And since the Welfare Reform Act 2009, unmarried mothers are generally required to name the father on the birth certificate unless there are exceptional reasons not to. So that strengthens this presumption somewhat.
Got it.
Yeah.
What about the HFEA exceptions to genetic fatherhood? This seems key for assisted reproduction.
Absolutely. The HFEA 2008 creates specific situations where the genetic father is not the legal father. The primary example is a man who donates sperm to a licensed clinic. That's Section 41 of the HFEA 2008. He is specifically stated not to be the legal father of any resulting child.
And this is to protect anonymity and encourage donation, presumably.
That's the policy rationale, yes. It allows donors to provide gametes without taking on the legal responsibilities of parenthood. Sort of clears the path for intended parents.
But what about DIY artificial insemination? Outside a licensed clinic, a private arrangement.
Ah, that's different. In a private arrangement, the sperm donor is usually the legal father. The protection offered by Section 41 only applies if the donation is made to a licensed clinic for their use. The setting matters legally.
Okay, licensed clinic versus private arrangement is a critical distinction. What about the husband? When the woman is treated in a licensed clinic, is he automatically the father?
Section 35 of the HFEA 2008 addresses this. If a married woman receives assisted insemination or embryo donation in a licensed clinic, her husband is treated as the legal father, provided he consented to the treatment.
That consent seems critical. Does it have to be consent to the specific treatment that actually happens?
Absolutely. And this is where the Leeds Hospital VA&B case from 2003 is really important. It was a difficult situation. Mr. and Mrs. A were undergoing IVF, and Mr. A consented to the use of his sperm to treat his wife. Standard stuff.
Right.
But due to a terrible mix-up at the clinic, another man's sperm, Mr. B's sperm, was mistakenly used instead. The court had to decide who the legal father was.
Oh, dear.
Yeah. The court held that Mr. A had not consented to that specific treatment, i.e. the treatment using donor sperm. His consent was for his own sperm. Therefore, Section 35 didn't apply to make him the father. And the genetic father, Mr. B, wasn't protected by the donor anonymity rules because it wasn't an intended donation to treat Mrs. A. So the court found Mr. B, the genetic father, was the legal father. It really shows how precise the consent needs to be under Section 35.
That's a really fine but absolutely vital legal point. Consent has to match the reality of the treatment. What about unmarried partners being treated in a licensed clinic?
Okay, so Section 37 of the HFEA 2008 allows a man who is not married to the woman but is treated with her in a licensed clinic to be treated as the legal father. This happens if they both satisfy the agreed fatherhood conditions.
Agreed fatherhood. What does that involve?
Essentially, they both have to consent, in writing, typically, to him being treated as the father, and neither withdraws that consent before the embryo is transferred or the sperm is used. It's a formal agreement process.
So this is the law trying to recognize intended parenthood outside of marriage, giving them a clear path.
Exactly. It replaced an older, vaguer, treated together rule from the 1990 Act and explicitly requires this clear, documented consent. The importance of consent in these scenarios was powerfully illustrated in the Evans v. Amicus Healthcare Ltd. Case, which went all the way to the European Court of Human Rights.
What happened there?
Miss Evans and Mr. Johnston had created frozen embryos together. After they separated, Mr. Johnston withdrew his consent to the future use of those embryos. Miss Evans wanted to use them. The courts, including the ECTHR in Evans v. UK, upheld Mr. Johnston's right to withdraw consent, even though it meant Mrs. Evans couldn't use the embryos they created together. It reinforces the principle that consent to the treatment must be continuing and specific, and can generally be withdrawn up to the point of use.
Yeah, it's a tough outcome, but highlights the legal weight given to ongoing consent. What about the tragic situation where a father dies before the child is born, but his sperm is used posthumously?
The law addressed this specifically. The Human Fertilization and Embryology Deceased Fathers Act, 2003, amended the HFEA 1990. A man can now be registered as the legal father of a child conceived after his death using his sperm, but only if he gave written consent specifically for the posthumous use of his sperm and specifically for his name to be registered on the birth register.
So, two specific consents needed in writing beforehand.
Yes. Without that specific documented consent covering both points, he is not legally the father, even if he's the genetic father. The case YVA Healthcare NHS Trust from 2018 dealt with the complexities around proving such consent.
So the law is trying to keep up with technology, but it requires very specific conditions and paperwork to be met. With all these rules and exceptions, are there situations where a child might end up having no legal father at all?
Yes, the HFEA 2008 framework does create such scenarios. For example, if a single woman undergoes assisted insemination in a licensed clinic using donor sperm, the donor isn't the father.
Huh.
If she's not married and there's no agreed fatherhood arrangement under Section 37, then the child will legally have a mother but no legal father.
Okay.
Similarly, if a married woman uses donor sperm in a licensed clinic without her husband's consent, so S.35 doesn't apply, and again, no agreed fatherhood, the child is legally fatherless under the HFEA.
That feels counterintuitive, but is a
Exactly.
direct result of how the statute defines legal parentage based on these specific conditions. Now, speaking of non-traditional families, what about female partners of the birth mother? How does the law handle that?
Right. For children born using assisted reproduction after 6 April 2009, the HFEA 2008 introduced provisions mirroring those for fathers to establish a second female parent. If the birth mother and her female partner are married or in a civil partnership at the time of treatment, the partner is treated as the legal other parent unless she can show she didn't consent to the treatment. That's Section 42(1) of the HFEA 2008.
So similar to the husband presumption for fathers we discussed?
Exactly. It mirrors that presumption. Now, if they are not married or in a civil partnership, the other woman can still become the legal other parent if she meets the agreed female parenthood conditions. That's Section 44(1). Again, this requires both women's consent to her being treated as a parent, documented before treatment, similar to the agreed fatherhood scenario for unmarried heterosexual couples.
And have there been cases testing this?
Yes, cases like Rececede Declaration of Parentage Written Consent from 2019 have examined issues around administrative errors in clinics and whether the consent requirements under Section 44 were properly met. It shows the importance of the procedural formalities.
So the law attempts to provide a clear route to legal parenthood for same-sex female partners, recognizing their intended family unit using parallel rules to those for fathers.
That's the aim, yes. But an important principle runs across all these HFEA provisions. A child can only have two legal parents at any one time under English law. and specifically only one legal mother, the birth mother, and one legal father. This means if a female partner is treated as a legal parent under Section 42 or 44 of the HFEA 2008, she is legally designated as the other parent, not a mother-in-law.
Right.
And in that scenario where there's a birth mother and a legal female other parent, no man can be treated as the child's father.
So if a child has a birth mother and a legal female parent established through the HFEA, they are legally fatherless.
Yes, that is the legal outcome of Sections 42 and 44 HFEA 2008 operating within the two-parent rule. It's about filling those two available legal parent slots.
Okay, let's try and make this concrete, using the examples from Activity 8.1 in the materials. First, Marianne, who is married to Niall, uses artificial insemination by donor, aid, at a licensed clinic, but Niall doesn't know about it. Who's the father?
Okay, right. So Marianne is the birth mother, so she's automatically the legal mother. That's clear. She used aid at a licensed clinic. Now, for Niall, her husband, to be the legal father under Section 35 of the HFEA 2008, he needed to consent to the treatment.
But the scenario says she did it unknown to Niall.
Exactly. So he clearly didn't consent to this treatment, the one using donor sperm. Therefore, Section 35 doesn't apply to make him the legal father. What about the donor? Well, sperm donated to a licensed clinic means the donor is not the legal father under Section 41.
Right.
So in this specific scenario, the child would be legally fatherless. Marianne is the mother, Niall isn't the father because he didn't consent, and the donor isn't the father because of Section 41.
Wow, okay. That lack of Niall's consent is absolutely key there. Second scenario. Mary and David use a surrogate, Susan.
Yeah.
Susan is inseminated with David's sperm. Who are the legal parents at the moment of birth?
Okay. Susan carried and gave birth, so under the HFEA rules we've discussed, she is the legal mother at birth. David provided the sperm, making him the genetic father. Now, this isn't a licensed clinic donation situation where Section 41 applies to protect a donor from legal parenthood. David is the intended father using his own sperm in a surrogacy arrangement. So David is also the legal father at the time of birth.
So at birth, the legal parents are Susan, the surrogate, and David, the genetic father.
Correct.
And Mary, the intended mother who commissioned the surrogacy with David.
At the moment of birth, Mary has no legal parental status under the HFEA rules. She didn't give birth. For Mary and David to become the legal parents, they, as the commissioning parents, would need to apply to the court for a parental order after the birth. This order, if granted, would extinguish Susan's and David's legal parentage and reassign it to Mary and David.
Okay, so the parental order is the crucial legal step for intended parents in surrogacy to gain that legal status. What is, in that same scenario, Susan the surrogate was inseminated using sperm from another man, not David.
Okay, Susan is still the birth mother, so she remains the legal mother. If she used another man's sperm, let's call him donor X, and assuming donor X is not a protected donor under Section 41, for example, it was a private arrangement or directed donation not covered by clinic rules protecting donors from parenthood in this context, then donor X, being the genetic father, would likely be the legal father at the time of birth.
So David would have no status.
Correct. David would have no legal parental status initially in that version. Mary and David would still be the intended parents, and they would still need to apply for a parental order. The order would aim to extinguish the legal parentage of Susan, the mother, and donor X, the legal father, and make Mary and David the legal parents. The criteria for the order might be slightly different regarding whose gametes were used, but the process is the same.
These examples really drive home that the birth mother rule is firm. Fatherhood depends heavily on genetics unless specific HFEA exceptions apply, and surrogacy always requires that separate legal process, the parental order, to sort out legal parenthood for the intended parents.
Exactly. Which brings us neatly on to discussing parental orders in more detail.
Right, parental orders. That special legal route for surrogacy, distinct from adoption.
That's right. They are specifically designed for situations where a child is born through a surrogacy arrangement and is being raised by the commissioning parents, the intended parents. Adoption is a more general process for children needing permanent families. Parental orders are tailored specifically to the circumstances of surrogacy.
The original HFEA 1990 introduced them under Section 30. What were the key features then?
It did, but it was quite restrictive initially. It only allowed applications from married couples. That was the first hurdle. And it required that the child be conceived using the genetic material of at least one applicant.
What did genetic material mean in practice?
It was generally interpreted as meaning at least one of the commissioning couple's gametes, egg or sperm, had to be used in creating the embryo. And importantly, it implied the child couldn't be genetically related to the surrogate herself. i.e., she didn't use her own egg, known as traditional surrogacy. Gestational surrogacy, where the surrogate carries an embryo unrelated to her, fit more easily. This Section 30 was influenced by early, difficult surrogacy cases like Re W. Minor's surrogacy from 1991, which highlighted the need for a specific legal solution.
What were the other conditions under the 1990 Act's Section 30?
Applicants had to be married, both over 18. At least one of them had to be domiciled in the UK, Channel Islands, or Isle of Man. They had to apply within 6 months of the child's birth. The child had to have their home with the applicants at the time of the application and the order. And crucially, the carrying woman, the surrogate, and her husband, if she had one, had to give their full, free, and unconditional consent to the order being made.
Consent from the surrogate was vital.
Absolutely. And her consent wasn't valid if given less than 6 weeks after the birth to allow time for reflection.
And what was the rule about money changing hands? Surrogacy payments.
Section 30 stated very clearly that no money or other benefit, other than expenses reasonably incurred, could be paid in relation to the surrogacy arrangement. This reflected the strong public policy in the UK that commercial surrogacy is unlawful. You can't buy a baby.
Yet I understand courts have sometimes authorized significant payments that look like more than just expenses.
They have, yes. This has been a tricky area. Cases like Re-S and Re-L, both from 2010, and JVG in 2013 involved courts authorizing substantial payments made to surrogates, often in overseas arrangements where commercial surrogacy is legal.
How could they do that if the law forbids payments beyond expenses?
The courts used a power first established in Re C 2002 to authorize the payments retrospectively if doing so was in the child's best interests. The paramountcy of the child's welfare became the guiding principle. If refusing the parental order solely because of the payments would leave the child legally stranded with the surrogate, who might be overseas and have no intention of parenting, the court could decide that securing the child's legal relationship with their intended actual parents via the parental order was paramount, and therefore authorize the payments. The unenforceability of surrogacy agreements themselves was noted by the Supreme Court more recently in Whittington Hospital NHS Trust v. XX 2020.
So welfare acts as a kind of safety valve for the court regarding the money rule, preventing the child from being penalized for the parent's actions.
It does, essentially. The child's stability and legal status often override strict adherence to the expenses-only rule in practice, provided the payments weren't egregious or clearly exploitative. The court still scrutinizes them, but welfare is the trump card.
Okay. The HFEA 2008 updated the parental order provisions under Section 54. What were the major changes?
The biggest change, which took effect from April 2010, was significantly broadening who could apply. It moved from just married couples to 2 people. This was defined to include married couples, civil partners of any gender, and crucially, also 2 people living as partners in an enduring family relationship who were not married or in a civil partnership.
So it opened the door to unmarried and same-sex couples.
Yes, but it still required 2 people applying together.
And that requirement for 2 people was challenged, wasn't it?
It was, under the Human Rights Act. In the case Rizzi, a child, no 2, in 2016, a single father who had commissioned surrogacy using his own sperm and a donor egg couldn't apply because he wasn't part of a couple. The High Court made a declaration of incompatibility, stating that limiting applications to couples discriminated against the child and the single parent, breaching their Article 8, private family life, and Article 14, non-discrimination rights under the ECHR.
And that led to another specific legal change.
Yes, directly. Parliament responded with the Human Fertilization and Embryology Act 2008 Remedial Order 2018. This introduced a new section, Section 54A, which now explicitly allows a single person to apply for a parental order. This came into effect in January 2019. It's a clear example of the HRA forcing legislative reform in family law.
That's a powerful demonstration of how human rights law can directly shape domestic legislation to reflect changing family realities. So for both single applicants under S.54a and couples under S.54, what are the current main requirements? Have the others changed much?
The core requirements, now applicable to both single and joint applicants under Section 54, as amended by the remedial order, are largely similar to the old ones, but with some key updates. The child must have been carried by a woman who is not the applicant or one of the applicants. The gametes of at least one applicant must have been used to bring about the creation of the embryo. This is slightly broader than the old rule, which sometimes caused issues if, say, donor eggs and donor sperm were used, but the couple were still the intended parents. Now, only one needs a genetic link.
Okay, only one genetic link needed now. What else? The application usually must be made within 6 months of the child's birth. However, courts have shown willingness to extend this deadline if the child's welfare demands it, as seen in React's time limit surrogacy from 2014. Welfare can override the time limit. The application usually must be made within 6 months of the child's birth. However, courts have shown willingness to extend this deadline if the child's welfare demands it, as seen in React's time limit. The child's home must be with the applicants at the time of application in order, and the applicant, or at least one applicant in a joint application, must be domiciled in the UK, Channel Islands, or Isle of Man. The application usually must be made within 6 months of the child's birth. However, courts have shown willingness to extend this deadline if the child's welfare demands it, as seen in React's time limit. Applicants must be over 18. The application usually must be made within 6 months of the child's birth. However, courts have shown willingness to extend this deadline if the child's welfare demands it, as seen in React's time limit. The carrying woman, surrogate, and any other person who is a legal parent, like her husband, if he's treated as the father, must give their free, full understanding and unconditional consent. As before, this consent is ineffective if given less than 6 weeks post-birth. Consent can be dispensed with if the person cannot be found or is incapable of giving consent, for example, to mental incapacity, and the money rule remains. No payments beyond reasonable expenses, unless specifically authorized by the court based on the paramountcy of the child's welfare. So while the range of applicants is rightly expanded, the core welfare-focused requirements, especially around consent and ensuring the child's security, remain central. And what about the very difficult situation where one of the intended parents dies before the order is made?
A recent case, Ray X from 2020, addressed this tragic scenario. The intended father died during the surrogate pregnancy. The surviving intended parent applied for the parental order. The court used its power under Section 3 of the Human Rights Act, 1998, to read down or interpret Section 54 in a way that was compatible with human rights.
How did they interpret it?
They essentially interpreted the requirement for the child's home to be with the applicants, plural, as including a situation where it was with the surviving applicant following the death of the other. This allowed the single surviving parent to obtain the parental order. The court explicitly did this to protect the child's Article 8 and 14 rights, family life and non-discrimination compared to children whose parents both survived, and to prevent significant hardship for the child and the remaining family. It's another instance of the HRA influencing the practical application of these rules in difficult circumstances.
These parental order provisions are clearly complex, evolving, but absolutely vital for recognizing and securing the legal status of families formed through surrogacy.
They are the specific legal pathway designed for that unique situation, balancing the interests of all parties, but ultimately focusing on the child's lifelong welfare.
Okay, now moving away from assisted reproduction specifically, how does the law handle disputes about who the father is in other circumstances, when paternity is questioned outside the HFEA framework?
This is where scientific testing becomes crucial. When the presumptions we discussed earlier, like the husband being the father or the name on the birth certificate, are challenged, courts have the power to direct DNA testing or other bodily tests under Section 23(1) of the Family Law Reform Act, 1969.
Can someone actually be forced to take a DNA test against their will?
No, not an adult. An adult cannot be physically forced to provide a sample for testing that respects their bodily integrity or autonomy. However, and this is a big however, the court can draw an adverse inference from a refusal to take a test when directed to do so.
An adverse inference, what does that mean in practice?
It means the court can essentially take the refusal as potential evidence supporting the conclusion the person is trying to hide. If a man refuses a paternity test, the court might infer that he likely is the father, or at least that he believes he is. It strengthens the other party's case.
Right. What about testing a child?
For a child under 16, the court can order the taking of a sample, like a mouth swab, even if the parent or carer objects, if the court believes the test is in the child's best interests. The person with care and control would be directed to facilitate the sample being taken.
So the child's welfare can override parental objection in that specific context of testing the child.
It can, yes. And the judicial attitude toward paternity testing has shifted significantly over the years. Older cases, maybe from the early 90s, like RAF A minor paternity test, sometimes showed a reluctance to order tests if they might disrupt what seemed like a stable, established family life for the child, even is based on a false premise about paternity. Stability was sometimes prioritized over biological truth.
But the modern approach is different. That's changed.
Yes, strongly so. More recent cases, like the Court of Appeal decision in Re H&A, paternity blood tests from 2002 have emphasized the fundamental importance of discovering the truth about a child's parentage.
Is that the case with the quote about truth?
Yes, Thorpe L.J.'s powerful quote from Re-H&A is often cited and really captures the modern view. He said, "The interests of justice in the abstract are best served by the ascertainment of the truth," end quote. There must be few cases where the interests of children can be shown to be best served by the suppression of truth.
Few cases. Best served by the suppression of truth. That's a very strong statement favoring finding out the reality.
It reflects the modern legal view that knowing the truth about one's origins is generally considered to be in a child's best interests and part of their identity. This echoes the sentiment in another case, Re-H minor, blood tests, parental rights, which suggested children have a right to know their paternity unless there are clear welfare reasons pointing the other way.
This connects back to the Human Rights Act again, doesn't it? Does Article 8, the right to respect for private and family life, actually give a child a positive right to know their parentage under the Convention?
This is an area where there's been some evolution and perhaps ongoing debate. Early European case law, like MBV UK back in 1994, suggested the convention didn't guarantee such a right per se. However, the English case Rose v. Secretary of State for Health in 2002, which specifically concerned donor anonymity, marked a significant shift.
What did Rose decide?
The court held that Article 8 was engaged. It found that the right to respect for private life includes the right to establish details of one's identity, and that knowing your biological parentage is a key part of that identity.
So Rose established that principle under Article 8 within English law.
Yes, the principle that the right to identity under Article 8 includes knowing one's biological origins, at least in principle. This decision was a key driver, alongside other factors, for the changes in the HFEA regarding donor anonymity. It led to the abolition of anonymity for sperm, egg, and embryo donors to licensed clinics for children conceived after 1 April 2005. These children can now request identifying information about their donor once they turn 18.
Though I understand that change had practical implications for donation rates.
It did, reportedly. There were concerns and some evidence suggesting a significant drop in sperm donations after the anonymity rule changed, illustrating that tension between the child's right to know and the practicalities of running gamete donation services. The European Court of Human Rights itself hasn't always been seen as perfectly consistent on this. Cases like Mikulik v. Croatia seem to strongly support the right to know paternity, while others like Ahrens v. Germany were perhaps less definitive in different contexts.
So Article 8 is engaged, the principle of knowing is recognized, but maybe an absolute enforceable right to know in all circumstances isn't completely settled, and domestic courts continue to weigh it against the child's specific welfare in the particular case.
That's a good way to put it. As seen in ABV, CD, and C 2019, the welfare principle remains the central lens through which English courts approach these decisions. And the wishes of older children, particularly if they are deemed Gillick competent, having sufficient maturity and understanding to make their own decisions carry significant weight.
Gillick competence again.
Yes.
Yeah.
In MSVRS and BT Paternity 2020, the court respected the wishes of a Gillick-competent teenager who explicitly did not want paternity determined or revealed. The court didn't force the issue against her expressed competent wishes.
So a competent child's wish not to know can actually override the general principle that knowing the truth is usually best.
Yes, in that specific context, the child's personal welfare, informed by their own autonomous wishes and understanding, was seen as paramount, even over the abstract principle of truth.
Is there ever a situation where, even if paternity is established perhaps through testing, the court would refuse to issue a formal declaration of parentage?
In very rare circumstances, yes, based on overriding public policy concerns. The recent case of HV, an adoption agency, number 2, from 2021, is a key example. Here, a birth father sought a declaration of parentage after his child had already been lawfully adopted by another family.
Ah, so the adoption had already happened.
Yes. The court held that granting the declaration of parentage in those circumstances would be contrary to public policy. Adoption creates a new, permanent legal family unit and severs the legal ties to the birth family. The court decided that undermining the security and finality of that adoption order by making a declaration about the birth father's status was not permissible for public policy reasons, prioritizing the integrity of the adoption process.
That makes sense. Adoption needs to provide that legal closure and stability for the child and the adoptive family. Now, Activity 8.2 in the materials asks specifically about the weight given to the welfare of the child when paternity is an issue. How would you summarize that?
Well, as we've discussed, welfare is the paramount consideration under Section 1 of the Children Act 1989 in any question concerning a child's upbringing. When paternity is disputed, the courts generally operate under that strong presumption, following cases like Re-H&A, that knowing the truth about one's parentage is in the child's welfare interests. It's part of their identity, their sense of self, and can have medical implications too.
So the starting point is truth is good for welfare.
Yes. It would require pretty cogent evidence, strong reasons to convince a court that suppressing the truth, maintaining a fiction, is genuinely in this particular child's best interests in the long run. However, as the MSVRS and BT case shows, the wishes and feelings of an older, Gillick, competent child who doesn't want the truth revealed can be given significant, potentially decisive weight.
So it's not an absolute rule. It's welfare assessed in the individual circumstances, but with a very strong presumption in favor of knowing the truth. That's a good summary of that tension between the general principle and individual circumstances. So to quickly recap this whole section on parentage determination, legal parentage isn't always the same as biological parentage. The mother is the birth mother, unless HFEA exceptions apply via parental or adoption orders. The father can be the genetic father or a presumed father, husband, name on certificate, or determined by complex HFEA rules covering donors, consenting husbands, unmarried partners under agreed fatherhood, posthumous conception, or established via adoption parental orders. We learned that the HFEA can lead to legally fatherless children in some scenarios. Paternity disputes outside HFEA often involve DNA tests under the Family Law Reform Act 1969, with courts able to draw adverse inferences from refusal. The modern approach strongly favors discovering the truth, Re-H&A, as being in the child's welfare, although this is weighed against specific welfare concerns or the wishes of a competent older child, MSVRS. The Human Rights Act, Article 8, underpins the right to know identity, prompting reforms on donor anonymity, but welfare remains the key judicial lens, and very rarely public policy might prevent a declaration, HV Adoption Agency.
That covers the legal parentage aspect nicely. It's complex but structured.
Okay. Moving on, let's talk briefly about the concept of legal status, specifically legitimacy and illegitimacy. I understand this is largely historical now.
Largely, yes. Historically, English law made a very stark, very important legal distinction. A child was either legitimate, meaning born within a valid marriage, or illegitimate, born outside marriage. This wasn't just a label. It had significant legal disadvantages for illegitimate children, affecting things like inheritance rights, claims against fathers, and even citizenship in some cases.
A really significant disadvantage based purely on parents' marital status, and that distinction has been abolished.
Fundamentally, yes. Legislation over many decades, particularly the Family Law Reform Act 1987, progressively removed the legal disadvantages associated with illegitimacy. The aim was to ensure children are treated equally, regardless of their parents' marital status. So the legal status distinction itself has effectively been abolished for almost all practical purposes.
Are there any tiny corners of law where legitimacy still technically matters, just out of interest?
Very few, and mainly for highly specific historical reasons. The source materials mention succession to the UK throne that's still governed by ancient rules, like the Act of Settlement 1701, which required descent through the legitimate line defined by marriage at the time. Also, historically, acquiring British citizenship automatically through the father depended on legitimacy, but this was largely changed by the Nationality, Immigration, and Asylum Act 2002, which allows unmarried fathers to pass on citizenship if paternity is proven. So, for the vast majority of people and legal issues today, the concept of illegitimacy has no practical effect. It's history.
Activity 8.3 asks if there's any reason to retain the concept of legitimacy at all. It sounds like for almost everyone there isn't a good legal justification anymore.
That's the strong argument, yes. Retaining the concept in law, even residually, arguably perpetuates an outdated and discriminatory perspective based on the parents' relationship rather than focusing on the child's rights and welfare, which is the modern approach embodied in the Children Act. Its abolition reflects a significant societal and legal shift towards equality for all children.
Okay, so legitimacy is essentially a historical footnote in modern English child law. This brings us to the concept that is absolutely central today: parental responsibility.
Indeed. This is the core concept that replaced those older notions of parental rights or authority. Historically, fathers, in particular, were seen as having almost absolute rights over their children. The Ray Agar Ellis case from 1883 is often cited for that traditional view, with very limited state intervention.
Right, the father is head of the household with near total control.
Pretty much. This gradually shifted over the 20th century, influenced by two key developments. First, the evolving welfare principle, the idea that in any question about a child's upbringing, the child's welfare must be the court's paramount consideration. Second, the growing recognition of children's own rights and developing autonomy.
And the Gillick case was pivotal here, wasn't it, regarding children's autonomy?
Absolutely. Gillick v. West Norfolk and Wisbech Area Health Authority in 1986 was groundbreaking. It introduced the concept of Gillick competence, establishing that a child under 16 could have sufficient maturity and understanding to make their own decisions, particularly about medical treatment, in that case contraception, even potentially against their parents' wishes or without their knowledge. This really marked a shift in recognizing children not just as passive recipients of care, but as individuals with developing rights.
And the Children Act 1989 then cemented this shift in language and concept.
Yes, profoundly. It explicitly replaced the old terminology of parental rights and duties and custody with the new single concept of parental responsibility, often abbreviated to PR. This was a very deliberate policy choice. The idea was to reframe parenthood primarily as a set of responsibilities and duties owed to the child, rather than rights held over the child, like property.
Shifting the emphasis from power to duty.
Exactly. As Lord Mackay, the Lord Chancellor at the time, explained, the purpose of PR is the responsibility for caring for and raising the child to be a properly developed adult, both physically and mentally. It's about the task of parenting for the child's benefit.
So what is the actual legal definition of parental responsibility in the CA 1989?
Section 3.1 and the CA 1989 provides the definition. It says parental responsibility means all the rights, duties, powers, responsibilities, and authority which by law a parent of a child has in relation to the child and his property.
That's interesting. It uses the word responsibility, but the definition itself still lists rights, powers, and authority.
It does, and that's important. While the name emphasizes responsibility, the actual content of PR still includes all the traditional rights and powers that parents need to raise a child, because the definition explicitly refers back to the existing common law understanding of what a parent does and can do.
So it's perhaps best understood as a duty-focused concept that contains the necessary powers and rights, which must be exercised for the child's benefit.
That's a very good way of putting it. And the courts have emphasized this philosophical shift. In Re-HB 2015, the Court of Appeal said PR is much more than a mere lawyer's concept. It involves duties owed by parents to the child and emphasizes that parents are the primary decision makers for their children, with the state and courts ideally only intervening when necessary to safeguard the child's welfare.
Okay, so we have the definition and the philosophy. What does this bundle of parental responsibility actually include in practice? What are those key rights, duties, and powers that someone with PR holds?
Right. The sources outline several crucial components, although it's important to remember this isn't necessarily an exhaustive closed list. The main aspects include, first, physical possession. Traditionally, parents had a right to the child's physical possession or custody. However, this right is definitely not absolute today. It's always subject to the child's welfare being paramount. In disputes, the child's own wishes, depending on age and understanding, are considered. And the state can intervene and remove a child if there's a risk of significant harm, under S.31 CA 1989 care proceedings. Also, someone with PR can lose the practical ability to demand the child's return from someone who has cared for the child long-term without a court order. And local authorities can't just keep a child accommodated under voluntary arrangements against the wishes of a PR holder unless the significant harm threshold for a court order is met, S20 CA 1989.
So, right, but heavily qualified by welfare and other people's roles. What else?
Second, education. A person with PR has the right to make decisions about a child's education, where they go to school, the type of schooling, etc. But alongside this right is a very important legal duty to ensure the child receives suitable education. That's under the Education Act, 1944, Section 36. Failure to do so is actually a criminal offense and can, in serious cases where the child's welfare is suffering significant harm due to lack of education, lead to court interventions like an education supervision order or even a care order. Cases like Re-O and Re-G touch on this.
Okay, well, right into duty there. What about discipline? This is often controversial.
It is. A person with PR may administer discipline. At common law, this included a defense for administering reasonable corporal punishment or reasonable chastisement. Cases like R.V. Deriviere dealt with what was considered reasonable. However, this area has seen significant change, partly due to human rights law.
The AVUK case.
Exactly. AVUK in 1998 at the European Court of Human Rights found that the UK's previous law on reasonable chastisement failed to adequately protect a child from treatment breaching Article 3, prohibition of inhuman or degrading treatment. This led directly to Section 58 of the Children Act 2004.
And what did Section 58 do? Did it ban smacking?
Not entirely. It significantly limited the defense. The defense of reasonable chastisement now only applies if the parent is charged with the lowest level of assault, common assault. If the physical punishment results in anything more than a very temporary or trifling injury, like reddening of the skin, for example, causing bruising, scratches, or worse, then the defense is removed. So any significant physical punishment is unlawful. It's a much stricter test than the old common law. And importantly, this defense is only available to parents or those acting in loco parentis. It was abolished entirely for schools much earlier. Wales has actually gone further and completely banned physical punishment of children more recently.
So a very limited defense remains in England, but much narrower than before. What's next in the PR bundle?
Fourth, religion. People with PR generally have the common law right to determine a child's religious upbringing. This goes back to old cases like Andrews v. Salt. If parents with shared PR disagree, the court can make a decision based on the child's welfare, as seen in Root G, Education, Religious Upbringing from 2012.
Yep.
Fifth, administration of property. This includes the power to manage any property or finances the child owns or inherits. An interesting side note is that under intestacy rules, dying without a will, only legal parents, not other people who might hold PR like guardians, can inherit from their unmarried children if the child dies intestate.
Right.
Sixth, representing the child in legal proceedings. Children generally can't bring or defend legal actions on their own. Someone with PR usually instructs lawyers on their behalf, acting as a litigation friend, although the court has discretion to allow a sufficiently mature child to participate directly or instruct their own solicitor in some family cases.
Seventh, medical treatment. This is a really complex and frequently disputed area within PR.
It really is. The rules vary significantly with age and competence. A young person, age 16 or 17, has a statutory right to consent to their own medical treatment under Section 8 of the Family Law Reform Act 1987, just like an adult.
So they can consent themselves?
Yes. But importantly, the case of Reed W., a minor, established that while a 16 or 17-year-old can consent, their refusal of treatment can potentially be overridden by the consent of someone with PR, or by the court, if the treatment is deemed necessary for their welfare. So their consent is valid, but their refusal isn't necessarily absolute below 18.
Okay, that's a subtle but important distinction. What about children under 16?
For under 16s, the Gillick principles apply alongside the PR holder's authority. A child under 16 who is Gillick competent, having sufficient understanding and intelligence, can potentially consent to treatment themselves. However, a person with PR also retains the authority to consent on their behalf, and if there is conflict, say, a Gillick competent child refuses treatment but the parent consents, or vice versa, the situation is complex. Cases like Re-R and Re-C suggest that a parent's consent might prevail over a child's refusal, or the court might need to decide based on welfare.
So multiple people might have the power to consent.
Potentially, yes. And for very serious, life-altering treatments like non-therapeutic sterilization, the courts have made it clear that parental consent alone is not sufficient, even if the child lacks capacity. Court authorization is required. Cases like Ray D. 1976 and Re B. 1988 and Re H. G. 1993 establish this need for court oversight for such grave decisions.
And human rights law affects this too.
Significantly. The Supreme Court case Re D, a child, in 2019 looked at 16, 17-year-olds lacking capacity. It held that parental responsibility is subject to the child's Article 5 ECHR right to liberty. This means parents cannot lawfully consent to arrangements that amount to a deprivation of liberty for their 16 or 17-year-old child who lacks capacity. EV placement and secure accommodation. That requires court authorization.
That's a major ruling on the limits of PR when fundamental rights were engaged. What about more routine but contentious issues like vaccination?
Recent cases show courts strongly supporting vaccination based on welfare. Read H. I. Child, parental responsibility, vaccination. 2020 involved a child in care, and the court upheld the decision to vaccinate against parental wishes. And Re C. looked after child. COVID-19 vaccination 2021 confirmed that a local authority with a care order could consent to routine vaccinations, including COVID and flu jabs, even if parents object, because it wasn't seen as such a grave decision requiring specific court approval in that context, and it aligned with the child's wishes and public health advice.
So welfare and public health considerations tend to prevail in vaccination disputes.
Generally, yes, when brought before the court. And remember, if a child is at risk of significant harm because parents are refusing necessary medical treatment, the state can intervene via an emergency protection order or a care order, allowing the LA or court to authorize the treatment under SS.31, 33, 34 of the CA 1989. Doctors are also generally advised they can provide essential treatment in an emergency without consent if necessary to save life or prevent serious harm. And ultimately, disputes about medical treatment can always be brought to court for a decision using wardship, the inherent jurisdiction, or specific issue-prohibited steps orders under Section 8 of the CA 1989. There's a long line of cases where courts have had to make these difficult life and death decisions.
Okay, medical treatment is clearly a huge and complex part of PR. What else is included?
Eighth, consent to marriage. For a minor under 18 to marry, they generally need the consent of everyone with PR, detailed in schedules to the Marriage Act 1949. If consent is refused, the court can override that refusal. Ninth, contact. Deciding who the child spends time with. Importantly, contact is not framed as a fundamental right of the parent within PR itself, but the courts recognize that a natural parent has a claim to contact that is an important consideration. Re KD. Disputes about contact are resolved nowadays via child arrangements, orders under Section 8 of the CA 1989, always based on welfare. We'll cover those orders in more detail in another deep dive.
Okay, and finally.
10th, determining the child's surname. This is another area that causes frequent disputes. Well, the general rule under Section 2.7 of the CA 1989 is that any person with PR can act alone. Changing a child's surname is a key exception. If there's a child arrangements order stating who the child lives with, a live-with order, then Section 13.2 explicitly says you cannot change the child's surname without the written consent of everyone else who has PR or the court's permission. Leave.
What if there isn't a live-with order in place?
It used to be thought that an unmarried mother could perhaps change the name unilaterally. However, case law, particularly the House of Lords decision in Dawson v. Wearmouth 1999, clarified the position. This was reinforced by the Court of Appeal in the combined cases W. A child, A child, B children, 1999. The clear principle now is that changing a child's registered surname is a significant step and requires either the agreement of everyone with PR or a court order based on the child's welfare, regardless of whether a formal live-with order exists.
So consent or court order needed in most cases if there's another PR holder.
Yes, if there's disagreement. The courts will apply the welfare checklist S.13 CA 1989 when deciding. Cases like Re-T, change of surname, 1998, outline the factors courts consider, such as the reasons for the change, the child's wishes, the existing connection to the name, and any potential confusion or embarrassment. And importantly, Dawson v. Wearmouth confirmed that a father who has acquired PR, for example via an order or agreement, has the legal standing to object to a proposed name change by the mother.
That is an extensive list of powers and duties covered by parental responsibility. It touches almost every aspect of a child's life.
It does, and as the sources note, this list is illustrative, not exhaustive. The courts have said the content of PR isn't frozen in time. Re-Z identification, 1997. The concept can adapt to new challenges and circumstances.
It's easy to see why disputes over these specific incidents of PR, like medical care, schooling, names, are so common in practice, and therefore common topics for exams. Activity 8.4 asks if PR should be more clearly defined in law, perhaps in a statutory list. What's the thinking on that?
It's a classic debate, really. On one hand, defining every power and duty precisely in statute could arguably increase certainty. It might make it clear what someone with PR can and cannot do, potentially reducing litigation about the scope of PR.
Sounds good. What's the downside?
The downside is inflexibility. The current definition, by referring back to the common law and remaining somewhat open-ended, allows the concept of PR to be flexible and evolve over time. Society changes, technology changes, our understanding of children's needs and rights develops. A rigid statutory list might quickly become outdated or fail to cover unforeseen situations. The current approach allows courts to apply the underlying principles of PR to novel situations, always guided by the paramountcy of the child's welfare.
So the classic trade-off, flexibility versus certainty.
Precisely. And the current law prioritizes flexibility guided by welfare.
Okay, excellent summary of the content of PR. So it's this bundle of duties and powers exercised for the child's benefit, covering everything from where they live and go to school to medical decisions, religion, property, legal representation, and even their name. And it's always governed by the welfare principle and subject to court oversight in disputes.
Right. Now, let's turn to the crucial question of who can actually hold this parental responsibility. As we've hinted, it's not limited just to the legal parents.
And you mentioned earlier, crucially, that PR can be shared by more than two people, unlike legal parentage itself.
Yes, that's a key point of difference and flexibility in the PR concept. Section 2.5 of the CA 1989 explicitly states that more than one person may have parental responsibility for the same child at the same time. And Section 2.6 adds that one person gaining PR doesn't automatically mean someone else loses it unless the specific legal mechanism involved says so, the main example of termination being an adoption order.
Okay, so who automatically has PR right from the child's birth?
The mother automatically has parental responsibility from the moment the child is born. This applies whether she is married or unmarried to the father at the time of birth. It's universal for all birth mothers.
Simple for mothers. What of the father?
The father automatically has PR only if he is married to the mother at the time of the child's birth. That's Section 2.1 of the CA 1989. Marriage at birth is the key.
What about the other parent under the HFEA 2008, the mother's female partner?
The legal female parent, like other parent, who is married to or in a civil partnership with the mother at the time of the treatment that results in the birth, also automatically acquires PR under the HFEA 2008 provisions. So her position mirrors that of a married father.
Okay, so automatic PR for the mother, always. The father if married to the mother at birth, and the female partner if married in a civil partnership with the mother at the time of treatment. That leaves the big category, the unmarried father. Does he get PR automatically?
No, he does not. This is the major distinction we discussed earlier in the context of human rights challenges. Under Section 2 of the CA 1989, the unmarried father does not automatically acquire parental responsibilities simply by being the father. He has to take active, formal steps to get it.
What are those specific steps he can take? That's under Section 4 of the CA 1989, right?
Correct. An unmarried father can acquire PR in one of four ways, listed in Section 4. 1. By obtaining a parental responsibility order from the court. He has to apply for it. 2. By making a formal parental responsibility agreement with the mother. This agreement must be in a specific legal form, signed and witnessed. It's a formal document. 3. By being jointly registered as the father on the child's birth certificate along with the mother. This only applies automatically for births registered after 1 December 2003, when this provision came into force. Joint registration before that date didn't automatically confer PR4. By being granted a child arrangements order by the court which specifies that the child lives with him. This replaces the old residence order under S.12 CA 1989. Being named as the resident parent in such an order automatically grants him PR via a deemed S.4 order. And importantly, the PR gained this way doesn't automatically terminate just because that specific child arrangements order might end later. It continues unless ended by a separate court order.
So unlike the married father, the unmarried father has to make a conscious, formal step agreement, registration, or court order to acquire PR.
Exactly. He must either agree formally with the mother, ensure he's jointly registered on the birth certificate post-2003, or apply to the court for an order. Now, when an unmarried father applies to the court for a PR order, what does the court consider?
Welfare, presumably.
Welfare is paramount, yes, under Section 1 of the CA 1989. The court also considers the presumption of parental involvement introduced later under Section 1.2a. This says the court should assume, unless the contrary is shown by evidence, that involving a parent in the child's life will further the child's welfare. This slightly encourages orders, perhaps, and the court must also apply the no-order principle from Section 1.5 as making this PR order actually better for the child than making no order at all.
How willing are courts in practice to grant these PR orders to unmarried fathers who apply?
The sources indicate they are granted in the overwhelming majority of cases. The courts generally look for three main things, often called the Re-H criteria from a 1998 case. First, the father's degree of commitment shown towards the child. Second, the degree of attachment existing between the father and child. And third, his reasons for applying for the order. Is he genuinely motivated by concern for the child? Or is there evidence he might misuse the status to interfere, harass the mother, or undermine the child's stability?
So if he shows commitment and attachment, and his motives seem genuine, he's likely to get it.
Very likely, yes. Courts are generally reluctant to refuse unless there's compelling evidence it would actually harm the child's welfare. For example, if the father has a history of domestic abuse, or has shown he intends to use the PR status simply to control the mother or disrupt the child's life, those might be grounds for refusal, as seen in the Re-H case itself, and also Rayam Parental Responsibility Order, 2013.
Can a PR order be granted even if the father doesn't currently have contact with the child?
Yes, absolutely. Cases like Re-Age, Contact, and Parental Responsibility from 1993 confirm this. The court might grant PR but make no order for contact, or even grant PR with specific directions about how it can or cannot be exercised, perhaps preventing the father from taking certain steps without a mother's consent, as happened in Re D 2006 involving lesbian mothers and a known father donor.
So it's sometimes seen as conferring a status, a recognition of fatherhood, as much as granting practical day-to-day powers.
That seems to be part of the court's thinking, yes. Recognizing the status and importance of a committed father in the child's life, even if direct contact isn't happening or is limited. Writer LJ in PMV MB&A 2013 spoke about conferring status on a committed father, so orders are rarely refused. It requires cogent evidence of likely adverse welfare impact.
Can an unmarried father's PR, once acquired, ever be terminated or taken away?
Yes, it can. This is another key difference from the automatic PR held by mothers or married fathers, which generally can't be terminated except by adoption. Parental responsibility acquired by an unmarried father under Section 4, or by a second female parent under the parallel Section 4ZA, can be terminated by a later court order. An application to terminate can be made by anyone with PR, or even by the child themselves if they have sufficient understanding, Gillick competence. That's under Section 42A of the CA 1989.
Has this actually happened?
Yes, there are reported cases. DVE, Termination of Parental Responsibility from 2021, is a recent example. The court terminated the father's PR because he had no relationship with the child, wasn't seeking one, and had been convicted of serious offenses against another child, making his retention of PR actively detrimental to the child's welfare and safeguarding. So termination is possible, but usually only in quite serious circumstances where continuing PR is clearly harmful.
That allows the law some flexibility to remove PR where it's actively detrimental. Now, Activity 8.5 asks for the arguments justifying that initial distinction between married and unmarried fathers regarding automatic PR. Why does the law maintain it?
The traditional justification usually revolves around the idea of commitment. Marriage is seen as a public, formal commitment undertaken by the couple to each other and implicitly to any children of the union made before or at the time of the child's birth. The law requires an unmarried father to take a subsequent active step like formally agreeing with the mother jointly registering the birth or seeking a court order to demonstrate a similar level of formal commitment and intention to take on the responsibilities of parenthood after the child is born. The argument is that this process encourages fathers to consciously and formally recognize their role and responsibilities.
So marriage signals commitment beforehand. Unmarried status requires a demonstration of commitment afterwards.
That's the essence of the traditional legal rationale. It has been and remains a controversial area, especially when viewed through a human rights lens focusing on discrimination, which we'll come back to shortly.
Okay, who else besides birth parents, mother, married father, unmarried father via SOPing 4, and the HFEA female parent can acquire parental responsibility?
Several other categories of people can acquire PR. Adoptive parents. They gain PR automatically when an adoption order is made under the Adoption in Children Act 2002, ACA 2002. Crucially, as we mentioned, adoption extinguishes the PR of all previous parents and anyone else who held it, like guardians. It creates a completely new legal parentage. Special guardians. These are appointed under a special guardianship order, also introduced by the ACA 2002, often used for children who can't live with birth parents, but where adoption isn't appropriate, for older children needing to retain family links. A special guardian acquires PR, which they can exercise almost exclusively in day-to-day matters. However, special guardianship does not extinguish the birth parent's PR, although the special guardian's PR takes precedence if there's a conflict.
So parents still have PR, but the special guardian is in charge.
Essentially, yes. Parents retain PR, but their ability to exercise it is very limited while the SGO is in force. Appointed guardians. Parents who have PR or existing guardians can appoint someone to be the child's guardian in the event of their death. This is done by will or a written dated instrument, Section 5 CA 1989. The court can also appoint a guardian. Appointed guardians automatically acquire PR, Section 6.
When does that appointment take effect?
An appointment made by a parent or guardian usually only takes effect on their death if, at that point, the child has no other surviving parent with PR, or if the deceased parent had a child arrangements order stating the child lived solely with them immediately before they die. So it doesn't automatically override a surviving parent with PR. Persons with child arrangements orders, residents. Anyone who is named in a child arrangements order as a person with whom the child is to live it's replaced the old residence order, acquires PR for the duration of that order, Section 12.2, CA 1989. This often applies to relatives or foster carers who get long-term orders. They gain PR via a notional Section 4 order. However, their PR is slightly limited. They can't, for example, consent to the child's adoption or appoint a guardian for the child after their own death. Second, female parent, not married to CP to mother. As we discussed under HFEA, a female partner who isn't married or in a civil partnership with the mother doesn't get automatic PR, but she can acquire it in the same ways as an unmarried father by agreement with the mother, court order, joint birth registration if applicable, or by getting a child arrangements order. That's covered by Section 4ZA of the CA 1989. Local authority with a care order. When a court makes a care order placing a child in the care of a local authority, the designated LA acquires PR for the child, Section 33 CA 1989. They share PR with the parents. However, the LA has the power to determine the extent to which parents can exercise their own PR if it's necessary to safeguard the child's welfare. The LA's PR is also limited. They can't, for instance, change the child's religion, consent to adoption, or appoint a guardian. Emergency protection order holder. Someone who obtains an EPO also gets temporary, limited PR for the duration of the order, primarily to ensure the child's immediate safety. It's this .44 CA 1989. Step-parents. Finally, a step-parent, defined as someone married to or the civil partner of a parent who already has PR but who isn't a legal parent themselves, can acquire PR. This can be done either by making a formal parental responsibility agreement with all other existing holders of PR, usually both parents, or by obtaining a specific step-parent PR order from the court. That's under Section 4A of the CA 1989.
That's quite the comprehensive list. It really shows how the law allows PR to be held by many different people who might play a significant role in a child's life. Parents, partners, adopters, guardians, other relatives, step-parents, even the state, via the local authority. It recognizes diverse family forms and the state's protective role.
Yes, it reflects the reality that children may be raised and cared for by various adults, and the law provides mechanisms for those adults to have the necessary authority and responsibility. And remember that key point from Section 2, 5, and 6. PR can be shared concurrently by several of these people.
How does that work in practice if multiple people have PR? Can they all make decisions independently?
The general rule is yes. Section 2.7 of the CA 1989 states that where more than one person has PR, each of them may act alone and without the other or others in meeting that responsibility. So for many day-to-day decisions, one person with PR can act.
But there must be exceptions.
There are crucial exceptions. We've already mentioned some. Changing the child's surname generally requires the consent of all with PR or a court order. S13.2 applies specifically if a live with order is in force, but the principle applies more broadly now. Taking a child out of the UK for more than 1 month also typically requires the consent of everyone with PR or court leave. And fundamentally, Section 2.8 says that no person can exercise PR in any way that would be incompatible with an existing court order concerning the child. Court orders always take precedence.
And the local authority's position with a care order.
Yes. As mentioned, the LA with a care order has that specific power under Section 33 to determine the extent to which parents can exercise their shared PR if necessary for the child's welfare. So the LA can effectively limit or override parental decisions in that context.
Can parental responsibility be delegated to someone else? Maybe temporarily, like a grandparent or teacher.
Yes, it can. Section 2.9 allows a person with PR to arrange for some or all of it to be met by one or more persons acting on their behalf. This covers things like consenting to routine medical treatment at school or allowing grandparents to make decisions while caring for the child. However, subsection 11 makes it clear that the person delegating remains liable for any failure to meet PR. You can delegate the task, but not the ultimate responsibility.
That's an important clarification. And what about someone who is just caring for a child day to day, but doesn't actually have PR, like a childminder or a friend looking after the child? Do they have any authority?
Yes, the Act provides a basic level of authority for them, too. Section 3.5 of the CA 1989 allows any person who has care of a child, but not PR, to do what is reasonable in all the circumstances for the purpose of safeguarding or promoting the child's welfare. This covers taking necessary steps in an emergency, for example, getting urgent medical help. It provides essential protection and authority for day-to-day carers.
Okay. Now, activities 8.6 and 8.7 in the materials essentially ask us to apply this section. 8.6 runs through the key points. Mother is birth mother, HFEA applies. Father is genetic presumed HFE order. Paternity presumptions rebutted by DNA. Child can be legally fatherless via HFEA. Female parent is the non-mother partner under HFEA. PR is automatic for mothers, married fathers, married CP female parents. Unmarried fathers, female partners need agreement, order, registration, or CAO. Factors for unmarried father PR order include commitment, attachment, reasons with welfare paramount. Mothers typically contest if concerned about misuse, undermining care, or harm. Activity 8.7 asks specifically about the significance of the REM parental responsibility order case from 2013.
Right. RAM is significant because it reinforces the point that while PR orders for unmarried fathers are commonly granted, there's no automatic presumption in favor of making one. The court must consider welfare, including the no-order principle. Riem upheld the refusal of a PR order where there was evidence raising serious concerns that the father would likely misuse the status to continue harassing and controlling the mother, which would be detrimental to the child's welfare. It highlights that the court focuses not just on the biological link, but on the father's specific conduct, intentions, and the potential impact on the child of granting him PR status in those particular circumstances. It shows the court will refuse if there's cogent evidence of likely adverse welfare impact.
That brings us neatly to our final section. Considering the impact of the Human Rights Act 1998 on these fundamental concepts of parentage, status, and parental responsibility.
Yes, the HRA 1998, which incorporated the European Convention on Human Rights into UK law, has certainly prompted scrutiny and challenges to existing law in this area. We've already touched on some points as we went along, but three key areas are often highlighted where human rights arguments have been raised or have led to change. First, the right to know one's parentage. Second, methods of parental discipline. And third, that distinction between married and unmarried fathers regarding automatic PR.
All right, let's take those one by one. We've already discussed the right to know under Article 8 ECHR quite a bit regarding paternity testing and donor anonymity.
Yes, and just to recap that briefly, while the ECTHR position might have some nuances across different contexts, English courts, particularly following the Rose v. Secretary of State for Health case, accept that Article 8, the right to respect for private and family life, is engaged and includes the right to establish elements of one's identity, which generally includes knowing one's biological origins.
And that led to the change on donor anonymity.
It was a key factor, yes. It led to the 2005 legislative changes allowing children conceived from donations to licensed clinics after that date to identify their donor at age 18. This was seen as striking a balance between the child's right to know under Article 8 and the potential impact on donation rates. But remember, in individual disputed paternity cases, the domestic courts still filter the decision through the lens of the child's specific welfare.
Okay, second area,
Sure.
parental discipline, specifically corporal punishment or reasonable chastisement.
This was directly challenged under the Human Rights Act, leading to quite significant reform, as we mentioned earlier. The landmark case was AV UK, decided by the European Court of Human Rights in 1998.
Remind us what happened there.
A young boy had been repeatedly caned by his stepfather. The stepfather was prosecuted for assault, but was acquitted by the English criminal court because the jury found the punishment amounted to reasonable chastisement, which was a complete defense at the time under common law. The boy then took his case to Strasbourg. The ECTHR found that the UK had violated Article 3 of the Convention, the prohibition of inhuman or degrading treatment, because its law failed to provide adequate protection to the child against treatment of that severity. The scope of the reasonable chastisement defense was too broad.
So the common law defense itself was deemed insufficient to meet human rights standards for protecting children.
Exactly. The ECTHR ruling in AV UK directly prompted Parliament to enact Section 58 of the Children Act 2004. As we discussed, this section didn't completely abolish the defense for parents, but it significantly limited it. The defense of reasonable chastisement is now only available for the very lowest level of assault, common assault, and is lost entirely if the physical punishment results in any injury beyond the merely transient or trifling. So while a minor smack might still be defended, anything causing bruising, marking, or more significant harm cannot be legally justified as reasonable chastisement anymore. Corporal punishment in schools had, of course, already been abolished much earlier, and the House of Lords rejected a challenge based on religious freedom against the school ban in the Williamson case.
So AD UK is a very clear instance where a successful Human Rights Act challenge directly led to a specific change in the domestic law governing parental conduct.
It was a direct legislative response to the finding that the previous domestic law on parental discipline was incompatible with the UK's obligations under the Convention.
Okay, finally, let's revisit that distinction between married and unmarried fathers regarding the automatic assignment of parental responsibility. Arguments were made that this difference reached the convention, weren't they?
Yes, absolutely. Challenges were brought before the European Court of Human Rights, arguing that the failure of English law to automatically grant PR to unmarried fathers was discriminatory and breached their right to family life.
What were the specific grounds argued?
The arguments were primarily based on Article 14, the prohibition of discrimination, read together with Article 8, the right to respect for private and family life. It was argued there was discrimination based on sex, because mothers always get PR automatically, but only married fathers do, and discrimination based on marital status, because married fathers get PR automatically, but unmarried fathers don't.
Yeah.
Arguments were also made that the distinction itself breached the unmarried fathers and potentially the child's Article 8 right to respect for family life by failing to automatically recognize the father's role from birth.
And what did the European Court of Human Rights decide on these arguments? Did it agree?
No, it did not. The European Court of Human Rights has consistently rejected these challenges. Cases like McMichael v. UK from 1995 and B v. UK from 2000 specifically considered and rejected the Article 14 discrimination arguments. And cases like Johnston v. Ireland from 1986 found no violation of Article 8 itself in this context.
Why did they reject the arguments? What was the reasoning?
The ECTHR essentially accepted that while family life existed between an unmarried father and his child, national laws could legitimately require some formal step or process for the unmarried father to acquire full legal parental rights and responsibilities. They saw requiring a step like agreement, registration, or a court order as falling within the margin of appreciation allowed to states, basically, giving countries some leeway in how they structure these rules as long as the process for acquiring PR was available and fair. They accepted it was a permissible way for national law to balance competing interests and formalize the father's position and commitment within the family unit.
So, despite the ongoing policy debate, and despite the steps taken domestically in the UK to make it easier for unmarried fathers to acquire PR over the years, like the joint registration rule after 2003, the ECTHR has not found the fundamental distinction itself, the lack of automatic PR, to be incompatible with the convention rights.
That's correct. The distinction remains embedded in English law under the Children Act 1989, and as far as the Strasbourg Court is concerned, it has survived these particular human rights challenges.
Okay, so to summarize the HRA's influence in these three areas, it has definitely pushed the law towards acknowledging and strengthening a child's right to know their parentage, particularly influencing the debate and legislative reform regarding donor anonymity, even if the application in individual cases remains welfare-focused. It directly led to a significant tightening of the law on parental corporal punishment following the AV UK judgment. And finally, while the distinction for unmarried fathers regarding automatic PR has been challenged on discrimination and family life grounds, the ECTHR has, to date, upheld the UK's position as being compatible with the convention.
That effectively covers the key areas where human rights principles and the ECHR have intersected with these core concepts of parentage and parental responsibility in English law.
This has been a really thorough deep dive into a truly fundamental yet surprisingly intricate area of English child law, determining legal parentage and then understanding parental responsibility. We've navigated the complexities of establishing who is the mother and who is the father, especially with the challenges posed by assisted reproduction and surrogacy, looking closely at the HFEA framework and the role of parental orders. We've explored the evolution of the crucial concept of parental responsibility, tracing the shift from parental rights towards duties owed to the child, and we've detailed that comprehensive bundle of powers and duties includes covering everything from education and medical treatment to discipline, religion, property, and surname changes.
And we've mapped out the various individuals and bodies who can hold parental responsibility, from the automatic acquisition by mothers and married parents to the specific steps required for unmarried parents, and including the important roles played by adopters, special guardians, appointed guardians, step-parents, those with court orders, and indeed the local authority in care proceedings.
We've seen how the Children Act 1989 provided that much-needed unifying structure for much of this law, aiming for coherence and clarity, and how the Human Rights Act 1998 has since prompted further evolution, specific reforms, and ongoing legal debate in key areas like discipline and the right to identity.
Absolutely. It's clear this area is dynamic, constantly adapting to new family structures, scientific possibilities, and evolving societal values about childhood and parenthood.
And for all of you listening, particularly those studying this area, understanding these core concepts, the key statutory provisions like those crucial sections of the CA 1989, the HFEA 2008, the FLRA 1969, and the significance of the landmark cases we've discussed is absolutely essential. It forms the bedrock for grasping so much else in child law and is vital preparation for your exams.
Indeed. You really can't understand disputes about where children live or about specific issues like schooling or medical care without first mastering who is legally considered a parent and what having parental responsibility actually means and entails.
Definitely. Now, as a final thought for you to perhaps carry forward and mull over, we've seen the law adapt in recent years, for instance, to allow single applicants for parental orders and to provide parallel routes for same-sex partners to gain parental status or responsibility. Given the continuing diversification of family structures and the ways children come into the world, should the law perhaps go further? Should the automatic grant of parental responsibility for unmarried fathers, for example, become the default position now, aligning them with married fathers? Or does the current requirement for an active step still serve a valid purpose in demonstrating commitment and ensuring clarity? It's a live debate. How might the law continue to balance the state's protective interest, parents' autonomy and responsibilities, and children's own evolving rights and welfare in the years ahead?
Important questions, ones that judges and policymakers continue to grapple with. Definitely something to keep in mind as you continue your learning journey in this fascinating field.
And on that note, we'll wrap up this deep dive. A huge thank you once again to the University of London for making these excellent materials available for educational use. We really appreciate it.
We do.
And thank you to Sinorbit Academy Sri Lanka for bringing you this conversation.
We truly hope this discussion has helped clarify some of the complexities surrounding parentage and parental responsibility. Best of luck to all of you with your studies and, of course, with your exams.
Yes, very best of luck.